I will focus on taking a charge over book debts as well as bank deposits. Those are things that we're not very familiar with. And I use those words advisedly when I say we're not very familiar with it. What I mean is that you would find in many documents an attempt to take a fees charge over everything. The question is whether that could pass the tests and the criteria that has been specified in many of the cases. I'm going to spend a lot of time on that. I would obviously spend a lot of time on the other quasi-collateral, what I call artificial security. They are just as effective, but they are not securities. And by that, I'm talking about guarantees, indemnities, negative pledge, comfort letters, and then I would leave some time for question and answers. Next slide, please. Next slide, please. It's not turning to the next one. All right, I can speak of the cough. So basically, the first thing that I need to let you know is that the relevance or significance of obtaining a charge is not only that when you go to courts, you can convert that collateral to liquidity, but it impacts directly on the capital of the bank, capital adequacy, and even liquidity ratios. Therefore, how does that happen? When I looked at the regulation of the central bank, I noticed that the capital relief that applies or attaches to a commercial mortgage is 100%. And the capital relief that applies to residential mortgage is 75%.
Okay, I mean, Mr. Eghobamien, you can go ahead.
Okay.
And then we can
All right.
keep dealing with the slides on the background.
Yes. All right. So basically, the regulation provides that the regulation provides 100% risk weighting for commercial mortgages and 75% for residential mortgages. Now, what that means effectively is that there is no relief. So there's a huge capital carrying cost when you take a commercial mortgage. And simplifying it to the very pedestrian level, what that means effectively is that the banks consider that you don't have collateral when you're dealing with a commercial mortgage. With residential mortgages, it gives a lower risk. Now, this is in compliance with the international standard, and that's because when commercial mortgages created a problem, if you recall, after the subprime crisis, it was taken that those assets may not be strong security. Now, the problem is even more serious in Nigeria, because when you take an action to courts and it's a mortgage-backed loan, the time it takes to convert that collateral to liquidity is such that the banks, the central bank in particular, is considering that you have no collateral whatsoever. Of course, the consequence of this is that the banks are reluctant to deploy funds to commercial mortgages. So the administration of justice is critical to how the banks maintain their books. The administration of justice is critical to how quickly you can convert an asset into liquidity. The other point to note is that it is not only the capital adequacy and capital of the bank that is affected, even the liquidity ratios are affected when a document or a bank security document is not effectively drafted, when the clauses are loose. And that is pretty obvious. It is obvious to the extent that if you obviously can convert the security into liquidity, the bank will be in a better position to meet its liquidity ratio. So there are different options that one could introduce to be able to circumvent these challenges that arises from just having documents that are sort of weak. One is to ensure that the documents go through an effective criteria. In other words, who are you using to draft your documents? I'm going to be looking at some clauses later in this particular lecture. And those clauses will demonstrate that although the bank assumes that it is protecting some risk, the risks are wide open, particularly when taking fixed charge over book debts or fixed charge over bank deposits. In fact, in one of the cases that we handled, we were required to give an opinion to a bank. I'll not mention the name for confidentiality reasons. Unfortunately for the bank, the litigation was in the UK because different bankers all around the world that had supplied credit to this particular borrower. And this particular bank, Nigerian bank, one of the big banks, of course, had taken security and taken a fixed charge on the assumption, of course, that it had priority. But when we looked at the documents, we immediately told them that your fixed charge will be recharacterized as a floating charge because there are certain protocols that you'll introduce into these agreements which were absent. That's very interesting because you have these issues with the bank where the bank is saying the documents are bulky without actually interrogating why the documents are bulky. What the customer wants is a slim document. Of course, many of these cases will never end in court and the clauses will never be interrogated. But it's almost like taking insurance, where you might simply say, I'm not going to take insurance because it is unlikely that the risk will materialize. But nobody operates like that. Everybody takes insurance. So there's a need to ensure that the documents comply, particularly because we're going into a new regime. And I just explained that. Today, a lot of the banks, if you look at their balance sheets, they actually obtain a lot of their profits from government treasuries. And as a result, you will find that all the banks, the big banks, will meet their capital adequacy very easily today because many of them only invest in treasury bills, government security, which has a very low risk indeed. However, with the new dispensation, the banks are going to have substantial capital. That capital will be required to fund long-term quality infrastructure, which are long-term, small and medium enterprises, as well as manufacturing industry. In other words, the banks will be compelled by the market to fund the real economy. At that time, banks will be required to actually carry out real banking, which means that all the risk that that will be identified needs to be covered. The consequence of that is that if you are funding the real economy, there must be mechanisms where you can either, let me put this forward. When you fund an infrastructure, and it will take 20 to 30 years for that loan to be totally repaid. When you fund a mortgage, a residential mortgage, it will take 15 to 20, 25 years. Most banks do not retain that particular fund on their books. They would actually find a mechanism to sell it to institutions that are better placed to fund those long-term institutions whilst maintaining the clients on their balance sheets. There's a mechanism by which that will be done. The central bank will ultimately introduce the regulatory regime that would allow for that. It means, therefore, that banks or bankers will need to look at their documentation that would allow them actually undertake such sales. Jennifer, are you back with the slides? If I follow the slides, right?
Yes.
Okay, good.
So we're on the introduction page. We can see the introduction page.
Fantastic. Okay. So take me back to so let's go back to you can take out Graham Fenn's photograph. I see that popping up. We don't need that anymore. Take that out. Okay. And you can expand it further. Expand the page further. So Jennifer, are you seeing the collateral and quasi-collateral?
Yes, that's correct.
All right. So let's go back. Let's go back. I just want to start and talk about the different hard collateral, and then I talk about the quasi collateral. So take us backwards. I'm going to take 2 slides backwards if you don't mind. Yes, and 1 step backwards. All right. Right. Thank you very much. Now, I was concluding the relationship or the interrelationship between your documents, collateral, and capital adequacy. So the importance of having effective documentation is not only that you want to succeed in court, but it actually helps the health of the bank itself. That's what you're going to be finding out when we go to the new dispensation. Today, most of the company secretaries and legal advisors will focus on the document for the reason that you want the court to ensure that the contract is enforceable and the collateral is easily converted to liquidity. But in the new dispensation, you're going to have a lot of pressure. Not only will you satisfy the legal criteria because the courts need to interpret those clauses, but there will be need to draft documents that are necessary to sustain capital adequacy, and liquidity. So let me go to the main security that we will normally deal with. And there are 4 of them. It's usually a mortgage, a pledge. We would also deal with the subordinations of mortgages. That is, I'm talking about now, equitable mortgage. And then we will deal with, the slide is out again. I will go ahead. So there are 2 types of collateral we'll talk about. We talk about the hard collateral and we talk about soft collateral. Soft collateral, you don't have, yes. Okay, you have the mortgage, you have the pledges. You got it now and you went back again. Just that diagram. Right. You have the mortgage, you have the pledge. And the mortgage, I did say you had 2 types of mortgages. And just keep it on this page. 2 types of mortgages, legal and equitable. I'll talk about them in great detail. Pledge is very interesting. You're going to have a situation where, of course, the traditional pledge would just be taking the goods itself, taking possession of the good, constructive or actual possession. But they're going to be, because the system is becoming more sophisticated, you're going to have documentary intangibles, documents that represent the rights to a particular asset, and abstract assets. So we talk about intellectual property, we talk about issues that are created by new technology. How do you take security over those assets? I think it's something that a bank will have to be interested in. I'm not going to spend time on that because they are specific and very extremely remote. And of course, there's insufficient time for that. Debentures and charges are more or less the same thing. I will talk considerably about charges because we've seen a lot of documentation within the jurisdiction which purports to take a fixed charge, but it is failed fixed charge. I will spend a lot of time on that. Debentures are simply just promissory notes that has incorporated in them the fixed or floating charge. Go to the next page, please. Now, I would run through this very quickly because I think all bankers are familiar with this. That is the legal mortgage. And that's the best security that you can have. If you have a legal mortgage, as far as it relates to residential property, you will get the necessary capital relief, right? As far as residential mortgages are concerned. However, we all know that obtaining consent is expensive and can be time consuming. So in most parts of the world, what the banks take is equitable mortgage. But in Nigeria, the consequence of taking an equitable mortgage, particularly where there is no consent, was interpreted in the case which we all know, Savannah Bank and Agilo, that the entire transaction was void. Now, that is a very serious matter for any bank. The borrower and the lender are proceeding under the assumption, erroneous assumption, that it has a legal mortgage, but it turns out that not having obtained consent, the court says it's an equitable mortgage. And interpreting Section 22 and Section 26 of the Land Use Act, it is a void mortgage. It simply means that that particular loan, the bank will have to make 100%, because usually when you're trying to exercise your right over the mortgage, it means the borrower is bankrupt and cannot pay. So you can imagine in Savannah Bank, having spent a number of years all the way to the Supreme Court, the bank lost out completely. We've moved one step forward, where the courts have now said that if there's an equitable mortgage, and if the banker or the creditor, the lender, was to apply to court compelling the borrower to seek the consent that he did not obtain, that should be sufficient, and the transaction will not be considered void. And that makes a lot of sense. So there's now some respite. But I think the problem that we face with that is that with time, as I said earlier on, international banking, banks do not keep assets on their balance sheet to maturity. Most banks will sell those assets. So when you create a mortgage in favor of the bank, and there is a need to sell the underlying loan to another party, maybe it be pension funds or the insurance or mutual funds, whatever. When you're trying to sell that, the collateral which has been created in favor of the bank, you would have to create a new set of mortgages in favor of the purchaser. That is expensive and it's inefficient. Therefore, what we will be recommending, in accordance with what is done in other parts of the world, is that whenever you're creating a mortgage going forward, and I think NMRC would also tell you this, create it in favor of a trust, a subsidiary of the bank. That trust will hold that mortgage in favor of the bank as full beneficiary. You will get the same capital relief that the central bank will normally give, even though since the asset is held fully in favor of the bank. The beauty of it is that if you then sell the loan, the underlying collateral, you simply only need to give instructions to the trustee to hold that asset in favor of the new purchaser. Through this method, you can adjust your risk weighting. Through this method, you can start going into securitization. But the central bank would have to have the regulation that allows for this to happen at the back end. So let me explain it this way. Today, we have the AMCON Act, which would allow you sell non-performing assets. But you don't have a regulation within the central bank that allows you sell performing assets. When I encounter a lot of bankers, they say, why would I want to sell my performing asset? I understand that. You might want to sell it because you want to restructure your books, you want to deploy capital to something else, and you still maintain that client on your books. As I said earlier on, when you give out a loan for 10, 20, 25 years in modern banking, nobody keeps it on his book till maturity. Usually it is sold to other funds that are better placed to manage those sort of long-term assets, particularly pension funds. So if we get to the position where we can create an asset-backed security and tranche those securities, you will find our banks will be more placed to fund the real economy. So what we have today is complying with the Basel III, but the tools necessary to reduce the harshness or to mitigate the harshness of the criteria in Basel III are not present in the Nigerian jurisdiction. This is something that I think the Chartered Institute of Bankers will take up with the central bank. The second point to note is that going forward, in looking at the documentation, especially with mortgages or indeed any other loan assets, you must be careful not to have any restrictive clauses that will limit your ability to transfer that asset to a third party. Banking has changed all over the world, so there is a need to look at the documentation and make sure that it's effective. So those are the only things I will talk about. All other legal issues, I can deal with that at a subsequent time so that I use time effectively. Go to the next slide, please. Enforcement. Of course, a mortgage, because you're transferring the assets, the property to the mortgagee, he now basically has a specific interest in the assets. He can sell these assets without necessarily going to court. And that is ordinarily the beauty of a legal mortgage. In selling it, of course, I think all the bankers here are aware that the equity of redemption is never extinguished. In other words, the idiom that we all came to imbibe in our first year law courses was that once a mortgage, always a mortgage and remains a mortgage. That principle continues to remain sacrosanct. And that's the beauty of a legal mortgage. Of course, you can also decide to foreclose, and foreclosure simply means that the equity in the property is extinguished. Usually that means that the loan, the outstanding obligation, supersedes the value of the property. So once you sell, the borrower is still indebted. So there's no question of him having any interest in the property. Of course, the other way of exercising or enforcing a mortgage is by appointing a receiver. And that is, you just need to be sure that the documents are watertight so that you can do that effectively. There are some nuances that are important as to how you take control of management in documents, but I think that is something that we'll deal with off this record. I want to focus on charges. And of course, taking possession of the property usually is constructive possession. No bank is interested in going to occupy any property. The one challenge that banks face, and this is a practical challenge, is that whenever the bank is interested in selling a property, particularly when it has a legal mortgage, and to sell it without reference to the courts, the borrower would usually proceed to court to obtain an injunction. It takes advantage of a ponderous system. That injunction that he obtains can be in the docket of the court for many, many years, maybe all the way to the Supreme Court. And again, at that point, the bank might have to make full provisions for that particular loan. It affects the bank's balance sheet. It affects his capital. It affects his capital adequacy. But there's a simple way to circumvent this impediment. And I always tell bankers that let your lawyers know that there's a principle in Nigeria that when there's a failed loan, when the loan is non-performing and it has a collateral like a mortgage, and the borrower has gone to court to stop the bank, or in the case AMCON, from selling the property, the Supreme Court has held that as a condition for granting that injunction, the borrower is supposed to pay the capital at the very least into court or directly to the creditor, the lender. We've used this method often. Whenever the courts declares that the borrower should pay the outstanding obligation, the capital, into court or to pay it to the bank, that usually resolves the matter. And it's even better when in drafting, some of these provisions are actually included. And I think AMCON has taken a lead around here because, of course, AMCON, as you know, is funded partly by the World Bank. We did some of those work, and its documentation is standardized that will enable it package those loans when they get to a certain level and then connect it with the capital markets. So I think it's important that that impediment is dealt with. The mode of creating equitable mortgage. Because of what I said about legal mortgage, when the bank takes an equitable mortgage, it takes a real risk because first, it doesn't get any capital relief. And secondly, in order to enforce an equitable mortgage, you must go to courts. We stated there the methods by which you create an equitable mortgage. I think everybody on this platform knows that. Simply, you deposit the deeds. There's an agreement to accompany the mortgage with an intention to create a legal mortgage. And the mere equitable charge on a mortgage is property. In other words, if you conduct yourself in a particular way where it could be interpreted that you were trying to create a mortgage, it's an equitable mortgage. Equity treats as done that which ought to have been done. So whatever has not been done, that will enable you satisfy the criteria to obtain a legal mortgage if there is sufficient interpretation that there was an intention to do so, that is enough for an equitable mortgage. But what is the practical challenge here? all equitable mortgages would have to be enforced through the court system when there's a failed loan or a failed obligation. The court system is ponderous, is inefficient. The dockets of the courts are full. So I said to the Chartered Institute of Bankers that in India, what they did was they formed a strong body of opinion to either educate those who are directly responsible for cases dealing with cases that are dealing with failed obligations and have collateral. You train them. I'm reluctant to say create specialized courts. That's not the answer, because you can simply just recycle mediocrity, not suggesting that you create specialized courts. What I'm suggesting is that the Chartered Institute of Bankers create a strong advocacy body that interacts with the NJC. I used to be a member of the NJC until last year. It's amazing how very few institutions interact with the NJC. And I can tell you the NJC is made up of retired judges and serving judges. And they live in a separate world of their own. They don't really understand how the court's interpretation would affect the banks and then affects the growth of the economy. That's failing to draw that connection sometimes leads the court to make decisions that have far more impact and wider implication in the economy than even the courts understand. I think there needs to be that advocacy created. So the biggest problem with equitable mortgages is an inefficient justice delivery system. Go to the next slide. Yes. It's just the same thing. I mean, the other methods, you can point to receiver. Usually that leads to litigation. Foreclosure leads to litigation because the equitable mortgages is only equity. Now, this brings me to charges. A charge is an equitable right because it is not, you don't have a right to the property. You are only setting an encumbrance on the property. That distinction is relevant because if you treat it as an equity, there are various ways in which you can enforce the right, as I said earlier on. So all charges are equitable in a sense to the extent that there is no property right that is transferred to the lender. So the encumbrance is used to secure the loan. In other words, you have an interest in that asset. If you have a fixed charge over the assets, what it simply means is that you have a charge which has priority over a floating charge. So a charge is demarcated into either it's a fixed charge or it's a floating charge. Fixed charge is used to be defined as a form of security interest that attaches to specific assets of the debtor, such as real estate, machinery, or investments. And I'm sure a lot of you will be saying, no, Mr. Eghobamien is way beyond his time. That used to be long, long time ago. Fixed charges now relates to inventory. It now relates to abstract property, including bank accounts and book debts. So the modern future of a fixed charge is no longer solely its attachment to specific assets, but rather the level of control the creditor has over the debtor's ability. In other words, the distinction between a fixed charge and a floating charge is not the fixed nature of the asset to which the charge applies, but it is the extent to which the charger has control or the chargee has control over the assets. So if the charger has control over the assets, it's effectively a floating charge. If the chargee has control over the asset, it's a fixed charge. That distinction has become extremely relevant, and that distinction informs how we create charges in our documents. Because the courts are quick to recharacterize a charge as floating when the parties intended it to be fixed. Usually, we are accustomed to a floating charge hovering over the assets of the borrower. It allows the borrower to continue to use the assets such that he can sell, he can create a charge, of course, subject to the agreements if there was an existing charge, but he can do anything with the assets. There are assets that continue to be cyclical. Assets that come in and go out, just like money comes into his account and goes out, just like inventory comes in and it is bought. You have a hovering charge. And when there is a trigger, that charge immediately becomes a fixed charge and limits what the charger can do with his assets, what the borrower can do with his assets in favor of what the lender should be able to do with the assets. So the floating charge, the characteristic about it is leaving the assets in full control of the borrower. Whereas a fixed charge, remember the origin used to relate to a fixed asset. And that fixed asset, there's nothing that the lender can do with it, like a machinery, it is there. With a fixed assets, control is fully and completely with the lender. The focus on control, just before we go to book debts, I'm going to deal with book debts separately from bank loans because they are two different things. The focus on control is critical because if that control is not there, even if your document says it's a fixed charge, the court will treat it as a floating charge. I did say that we gave an opinion once. The bank did not like the opinion because we said that you have not satisfied the criteria stated in Respectrum on what it takes to obtain a fixed charge in your favor. This charge is likely to be recharacterized. And this was a lot of money, dollar denominated. Eventually, the liquidator took over. The liquidator went to court in the United Kingdom, and the bank lost everything because it was now considered a floating charge. Of course, the amount of money it got when the funds were there was pari passu shared. In other words, shared in proportion to the loan that each of the creditor had given, because they were all floating charges in accordance with priority who created their debt first. This particular bank that actually had created this charge first as a fixed charge, who would have been totally satisfied if that documentation was effective, lost out completely. It's important that you have experts draft your documents. And let me digress. When I encounter bankers, particularly in Nigeria, and they give us documentation to draft, and we say, look, this is going to cost you this amount of money. And that's because we're having our partners travel abroad, we're having our partners monitor what is going on around the world, we're having our partners and associates trying to understand the principles. And then we infuse that into your documentation. Now you have a young lawyer who's 2-3 years who comes in and says, oh, Hutchinson and Grace, some other commercial law firm will do this for, I don't know, 50 million. I can do it for 7 million. He's doing it for 7 million because the extent of his documentation is limited to his knowledge. And therefore, you are comparing apples and oranges, clearly. And I say to quite a number of the bankers, I'm sorry, I can't do it. It could cost us a lot of money to do all the investigation. When I tell you what it takes and the risk you are facing, of course, naturally, 85% of these loan documentations will never end up in any disputes, and so you get away with it. But God help you if it ever gets there. And that's the way you do deal with insurance. You don't take out insurance only because a risk will materialize. You take out a risk so you cover and mitigate the possibility of a risk actually having happened. And I think this is one area that bankers will have to focus on, because you're going to be finding out that the assets that you are taking security over is changing considerably. You are going to have talented young people in the hospitality, intellectual property. You would have book debts. You have charges over bank deposits. There will be a need to focus directly on the expertise that is required so that your security or your collateral retains its priority. Go to the next slide, please. What is a book debt? No more than what the name says. It's a debt in a book. So, I mean, for everyone on this platform, I don't need to explain that in any great detail. any going concern, except its cash and carry, will have its customers owe it some money. That has become a big part of the collateral that banks are looking up to, because the debt that is owed by quite a number of customers are extremely formidable in terms of, if you look at the counterpart of who's owing you, it's usually very good. And the bank wants to be able to revert to those assets in the event that the borrower is unable to pay. And better still, if you can take a fixed charge over the assets. So I define there that a book debt represents money due to a person in the ordinary course of business. The word ordinary course of business is what distinguishes a book debt from a bank deposit. They're usually the same principle, because the bank is indebted to you when you create a credit in favor of the bank. In other words, if you deposit funds in the bank is also indebted to you, just like a customer is indebted to you. The difference is that one is generated in the course of the business, the other is generated as a result of a loan borrower relationship, a banker-customer relationship. The debt may be a current payable debt or a debt paid in the future. What is important is that there's an outstanding obligation to the borrower, and he wants to assign that obligation to the bank, or he wants to charge that obligation to the bank. Assignment of that obligation is a different thing, that's factoring, but he wants to enable the bank to charge that asset. And the bank wants to have priority for obvious reasons, because this borrower has interacted with many other creditors, and the bank wants priority in the event that the particular borrower either goes bankrupt or is insolvent. The charge on book debts is registrable, and I don't think any bank will fail on that. Usually it will be incorporated in the debenture. That's a very interesting point, and you will see the failing when you do that. Go to the next slide. How do you take a fixed charge over a book debt? This is very important. I think I would just go through it, but what I've done in the subsequent slide is to actually pick out a particular clause from documents that are floating around. Most banks have confidentiality with their documents, so this is a generic clause that I've picked out, not from any particular bank. But you will notice that most banks use similar documents, and that's not a bad thing. But the problem is that if one bank has documents that are poorly drafted, all other banks are usually going to depend on that poorly drafted document, because everyone is using the same document, and we see a lot of mismatch when you pick out clauses that don't have any coherence, and you will see that in a minute or two. So how do you get a fixed charge over a book debt? Remember that the book debt is constantly rotating. In other words, you are having customers pay, and then you generate an obligation which is satisfied by proceeds of funds. So that is a moving asset. It's an intangible moving asset. So it creates its own complexities to take a fixed charge over it. And we said earlier on that control is critical. You must have control over that particular asset. How do you take control? So in a particular case in the United Kingdom, they developed what we call the triple cocktail test. First, the document must expressly state that the charge is fixed. That's easy. That is a form rather than substance. And then, in the same documents, there must be clauses that restrict the use of those funds, and there's total control given to the bank. There's a mechanism by which that is done, but it must be clear that the bank is in control of those funds. And that will usually be done by all proceeds from the debts are paid into an account in the company's name, or in the bank's name with the lender. In other words, the company's name with the lender, but the company doesn't have full control, doesn't have control. Usually the company will be a signatory to that account. And finally, the account is blocked. In other words, you can't access those funds without the bank giving you permission to do so. What normally happens in practice is you have a protocol, and that protocol will have an officer of the bank who will normally just be superintending over the account. So it's not as complicated as it looks, but that protocol Usually in your agreement, you refer to that protocol and it will demonstrate, and your conduct will also demonstrate that the bank is really in control. And then you have a sweeping clause that takes the money out of the bank through the bank's control. Once you do that, you could satisfy the test of a fixed charge. And if the borrower were having any difficulty, you could actually, well, we're dealing with a book debt. Let me limit it to book debt. You could now satisfy the criteria of having the customer to that borrower, having that customer pay those sums to the lender, or you having a charge over that particular proceeds. The problem, obviously, is that many of the drafted clauses do not have any of these provisions. I want to move forward and then I'll come back. Go back to a clause that I have identified, which I see in a lot of documentation on how a fixed charge was taken. Right, a triple cocktail. This is a simple clause. The company charges by way of a fixed charge, so it satisfies the first criteria in form. And first charge, it even goes to prioritize the charge. It doesn't need to, because once it's a fixed charge, it's obviously a priority as long as it's created before other charges. And first charge to the trustee, and this was to the trustee, that's a good thing, all books and other debts. So it charges a book debt and other debts, revenues and claims, both present and future. So it's existing book debt as well as future book debts, including bank deposits. So it is taking a fixed charge over the book debts and bank deposits. Two different types of characteristics, assets, two different types of assets that share slightly different characteristics, but they're all now in one clause. And credit balances, uncalled capital, goodwill. Goodwill is very interesting. How do you take a charge over goodwill? Fixed charge. And all patents. That's another very interesting asset. Patent application, inventories, trademarks, trade names, registered designs, copyright, and all licenses, ancillary rights, and benefits, including all royalties, fees, and other income deriving from the same both present and future of the company. Very broadly stated. But I think the most important thing is that it takes a fixed charge over the book debts, takes a fixed charge over bank deposit, takes a fixed charge over documentary intangibles, take a fixed charge over pure intangibles. Okay. Usually you will see this clause will be mixed with debenture clauses, and there'll be all sorts of clauses, what we'll normally call belt and braces, all sorts of clauses. Now, none of this satisfies the criteria that was stated in an English decision. And the Nigerian courts will follow that. Let me say that very quickly, because fixed and floating charges, as in the Companies Act, is exactly drawn from the UK's Companies Act of 2006. So there's a better way to do this, but I will not go there first. Let me revert back to just going through the process of what needs to be done. So take me back to the 2 slides backwards, please, if you don't mind. Right. So what will cause the court to recharacterize a fixed charge into a floating charge? And that is a disaster for any bank. I mean, let me give you the scenario of what we're talking about. Let's say we take Dangote's refinery, and there were syndicated banks, both international and local, that funded that particular project. And some of the banks take a fixed charge over the receivables that we have today. In other words, oil receivables. They're doing a lot there. A lot of people are engaging in the refinery. They have book debts that are huge. Those debts are being used currently to satisfy the extensive obligation that Dangote went in. You can just imagine proceeding under the erroneous assumption that you have a fixed charge, and for any reason there's a trigger. And the trigger may not be as a result of insolvency. It might be a cross-default clause. It might be anything. There's a trigger. And all of a sudden you realize that your priority is subordinated to even a floating charge. It's a disaster. So what will cause the court to recharacterize your charge, or the liquidator in bankruptcy, or the insolvency practitioner? They're as follows. If and let's take Dangote for one moment. If the borrower continues to run his accounts just the way any account is run, then you have failed in obtaining a fixed charge, even if the document is expressed to be fixed. Now, there is a clause that restrains the borrower from creating any other charge over and above the fixed charge. That is insufficient, because I saw that in a number of documents that we've had to encounter, both as litigators and in some other cases, we've used it for other things that we were engaged with, particularly with Graham Penn. The restraining of the borrower from taking or creating a superior charge is insufficient. That is distinct from restraining the borrower from access to a particular account. They're two different things. So when I see clauses where there's a lot of restraining, and that will usually happen, including a negative pledge, I'll talk about that, that in itself does not satisfy the criteria. It is important that there's a restriction to the debts and the proceeds that arise from that debts. And I think that is the condition that you must satisfy. You must satisfy to give priority to your charge and to the indebtedness to the particular bank. Go to the next slide, please. Now, bank deposits have characteristics that are similar to a book debt. But as I said earlier, it is not created in the course of a business. It is created as a result of a banker-customer relationship. But I think the uniqueness of bank deposits is the fact that once you deposit funds in the bank becomes the debtor and you become, in a manner of speaking, the creditor. In other words, the bank is under an obligation to satisfy that demand anytime it is made. So banks will normally take a charge over an account that is funded as a condition for giving a loan in respect of another account, maybe an overdraft account. And that used to be the safest security, what we call almost cashback. However, a very brilliant judge in England came up with the concept of conceptual impossibility. And I must confess, there's strong argument, and it existed for quite a while in the UK, which is that a bank cannot take a charge over an account that is maintained with the bank. If you recall, we said a charge is an equitable right. Therefore, the only way in which you can actually actualize that charge is by appointing a receiver. How can a bank appoint a receiver to act over an account which belongs to itself? So you are going to have the bank suing itself to actualize that debt. It's just impossible. So I think it was Brightman who said that that was a conceptual impossibility. Of course, that threw the commercial world in the United Kingdom array, because a number of security documents which had followed a particular way of drafting, thinking that they had a charge over bank accounts that were kept with themselves, all of a sudden found out that the charges were not effective any longer. As a matter of fact, that was one of the arguments put forward by lawyers, that if these courts in England were to consider this methodology of creating a charge as a conceptual impossibility, it will render a number of the securities kept by banks retrospective. It will render it null and void. The court was not persuaded by that, particularly because the cases that established that you could do that were first instance cases. The court decided that the court decided that that was not sufficient to render it a nullity. However, practitioners have gone one step forward to deal with that problem. And that is what we need to do if you want to take a charge over a bank deposit, which is as follows. You must create what is called the triple cocktail. The triple cocktail requires you to first create a charge over the deposits. 2, create a contractual right of set-off. So what does that mean? It means that you simply let the customer know that you will set off its indebtedness with the credits in its account. It's a contractual thing, but it's not a charge. And the reason why it is not a charge, that's set off, why it's not sufficient, is that if the borrower were to go insolvent, you would have somebody else take priority. So something else had to happen, which is what is referred to as the flawed asset arrangements, which means that the liability of the bank to the borrower is contingent on the borrower meeting his obligation in the separate accounts. So the bank is not liable to satisfy a demand from the borrower. Remember, there's a banker-customer relationship, and the bank is always under an obligation to satisfy that demand. So when the borrower issues a demand to the bank simply says that by the agreement I have with you, I will not satisfy this obligation unless you make good an account which is in deficits. It's called the flawed asset clause, flawed asset arrangements. In other words, and the importance of that is this: supposing the borrower were to go into liquidation, the liquidator would be looking at that account. And remember that originally the bank was indebted to the borrower, and the liquidator is subrogated into the rights of the borrower. The liquidator steps into the shoes of the borrower. So ordinarily, the liquidator simply needs to issue a demand, and that account will flow. The proceeds from that account will flow to the liquidator. So, but with the flawed arrangements, the bank can say to the liquidator, no, the liability has not arisen. It is a conditional liability. And unless you, the liquidator, satisfies that indebtedness, you are not entitled to these proceeds in this account. Only if you prepare your documentation in that form will the courts consider that you have a fixed charge over a bank account. Now, when we move to the new dispensation, and when the bank starts funding the real economy, you're going to have a lot of assets that constitute bank deposits as well as book debts. And therefore, it will be important to get the security right. Today, if you look at the balance sheet of the banks, they're funding government securities. That's what makes the subject of most of the banks' assets. And so the banks are doing well. But when this capital is enhanced, you're going to have a margin of capital that must be deployed, because government is not automatically going to increase its borrowing. And that capital that will be deployed will have to be deployed, as I said earlier on, to long-term infrastructure, SMEs, and manufacturing industry. Of course, I understand that the macroeconomics might affect what happens, but I'm sure the Minister of Finance will be looking at fiscal issues when we get to that point. But the banking landscape is going to change. There's going to be a lot of emphasis on documentation for many reasons. Even investors who are coming will be interested in looking at the underlying assets to see whether they should invest. And as I said earlier on, the assets itself will be affecting capital and capital adequacy. Go to the next slide. I want to demonstrate something to you. So this is a generic triple cocktail that is taken over a bank account. I would give you a minute to just read it, please. But I've put a danger sign by the end. Please don't adopt it simply because I put it. This is extremely generic. What normally happens is that what I see locally is that banks who don't want to spend money, I understand that, but be very careful. Pick up clauses and just introduce it, and there's a mismatch of clauses. So you have a clause that is generic, applies to all the assets, takes a fixed and floating charge. Then you pick up a clause like this here, which is specific. Of course, if you have a generic clause that allows the banker to use the assets, you then have these clauses that are specific, which satisfies the criteria. I can tell you that the charge will be recharacterized for the simple reason that you have a general clause that gives the bank a right to proceed. You have a specific that satisfies the criteria, but the existence of that general waters the specific down. The point I'm simply making, and I will reiterate that point over and over again, because I've seen a lot of documents here where there's a mismatch of documents all over the place, clauses, and it's just thrown around. But this is what ordinarily will satisfy the triple cocktail test. I will give 2 or 3 minutes just to take a bit of water while you read this clause very carefully, because we're going to talk about it when there's a question and answer. You will see that this clause is attempting to replace the earlier clause, which is just a single clause, which purports to cover all the risk. This clause is a 3-paragraph clause which supersedes and takes the place of the other clause. I am repeating this because often enough when I encounter bankers, they say, I want a simple documentation. But you can't trade risk for simplicity. So I say to them, well, I'm sorry, because I know the sort of risk you're going into, I can't give you a simple documentation. And interestingly, most of the bankers, when they're dealing with the international counterparts, they're prepared to accept it. But when you're dealing with a local lawyer, there's a resistance. So let me give you 3 minutes just to read this clause to make sure that we capture the triple cocktail. Just 2-3 minutes while I take some water. Thank you.